All right, I've got 9 o'clock. Good morning again. Welcome to oral argument session here at the 5th District Court of Appeal. I'm Judge Harris. Also on the panel today, Judge Eisnagel and Judge Wozniak. The proceedings are being recorded and live streamed on YouTube, just so you're aware. The first case we're going to deal with this morning is Carabeo Carpet versus People's Trust. It's case number 20-1486. Each side is given 20 minutes for their argument today. Appellant can reserve as much of that as you would like for a rebuttal. Just let us know. So with that being said, appellant, if you are ready, you may proceed.
Yes, may it please the court, Jose Font. Good morning again on behalf of the appellant.
Good morning.
If I could reserve 5 minutes.
Yes, sir.
Thank you. The claim in question is under an all-risk policy where there's no factual dispute that there was a covered peril as defined by the policy, which is any direct physical loss to property during the policy period. In this particular case, it was a broken, ruptured supply line for which, under an assignment of benefits, my client performed plumbing repairs, performed the removal and disposal of damaged debris, the removal and disposal of contaminated debris. Coverage was accepted. However, the only operative issue, as established by way of the summary judgment, the corresponding interrogatory answers, and the corporate representative deposition of the appellee, was that they relied on a payment provision under an additional coverage section of the policy. This additional coverage section of the policy is not the primary coverage section of the policy. Under the primary coverage section of the policy, and if you view the testimony of the corporate representative of the appellee, there's not a singular exclusionary provision that would serve to bar the repairs in question. Not one scintilla or indicia that this policy under coverage A, the loss payment provision, does not allow for, amongst other things, the items that I mentioned, which is a plumbing repair.
You have to read, and I apologize, I'm dealing with some laryngitis today, but you have to read the endorsement and coverage A together, correct? It's all part of one contract?
Yes and no, because the operative payment provision, if you look upon it, it says we will pay you for your reasonable repairs. However, if it's solely to protect the property from further damage, then and only then can you apply the $2,000 payment limitation. So the question is, what is solely to protect the property from further damage? Does that include the repairs to the plumbing system? The answer is there's no basis to say otherwise, that is in fact not solely to protect the property from further damage, otherwise payable under coverage A. The additional coverage provision is a provision that runs in conjunction with, for example, the bacterial contaminants as documented in the invoice. Those are not covered under coverage A. Those are not items that need to be accounted for solely to protect the property from further damage. It's part of the rebuild process is to remove the contaminants and damaged debris. And even assuming arguendo, which there is an exclusionary provision that would draw applications or coverage A, as relates to fungi or bacteria, there's no coverage. You have to look upon, and specifically, the court can look upon the additional coverage section. It starts off on record 75, and then you have the fungi provision, which starts on record 81. What's important, especially important, beyond the obvious consideration of this is $10,000, not $2,000. This is an additional coverage which says, in the event of, there is bacteria, contaminants, toxins. In this particular case, they categorize as category 2 and 3 water in the invoice. You get up to $10,000 and not to be limited by that $10,000. If in fact there's coverage somewhere else, you're entitled to that coverage somewhere else. And that's specifically on record site 82, subparagraph 4D. If there's a covered loss, which again is any direct physical loss to property during the policy period, not caused in whole or in part by fungi, wet or dry rot, or bacteria, loss payment will not be limited to the terms of this additional coverage. To the extent that fungi, wet or dry rot, or bacteria cause an increase in the loss, any such increase in the loss will be subject to the terms of this additional coverage. So the question is, where in the record below or otherwise in the brief presented by the appellee, do they address the wet rot, the bacterial conditions, the category 2 and 3 water is documented, the contaminants that need to be removed and disposed of arising from a covered peril, which is the loss in question. They do not, and they cannot. Specifically, in addition to that, we go back to another additional coverage section as the same operative considerations that in fact increases coverage for debris removal. And it says, we will pay your reasonable expenses for the removal of debris of covered property if a peril insured against that applies to damaged property causes the loss. So here, there was a broken supply line. The ensuing moisture conditions required, amongst other things, the removal and disposal of the building materials, specifically the baseboards, throughout 6 different areas of the home. Why was this coverage section not accounted for? In combination with the bacterial conditions, the fungi conditions, the rot under the additional coverage provisions, the answer doesn't exist. So if you look upon the endorsement provision, it states in the event of you not complying with the notice requirement, so that we can invoke rapid responses services, because the services at issue were not invoked, at least as presented in summary judgment form or affirmative defenses or discovery wise, as to the coverage A rebuild repairs, which would include the plumbing, would include the removal and disposal of the damaged materials. However, even if you look at that endorsement, you have to look at it carefully, because it says we will pay you in the event that you do not provide notice the reasonable cost of the repair expenses incurred, or otherwise the amount that we would have paid rapid response, not for the repairs as a whole, but solely is a key operative term to protect the property from further damage. So the question is, did they establish that each and every service was solely to protect the property from further damage? The answer is they did not. They drew a monolithic, broad brush, all-encompassing term of what constitutes either emergency services or remediation services. But emergency service can include a permanent repair, such as a plumbing repair.
Looking at your invoice, what are the items on the invoice that would not fall under that rapid response contract?
Well, I would suggest the burden would rest pursuant to the case law on the insured to establish a solely to protect the product for the damage. However, specifically, if you look at the invoice, they're accounting for antimicrobial application. They're accounting for the utilization of a HEPA filter to deal with the category 2 or 3 water. None of those items are solely to protect the product for their damage. That's part of.
What else are they for? Isn't it to, like, the antimicrobial, isn't that to prevent mold, which would be further damage?
It certainly encompasses, just as much as the plumbing repair encompasses to protect the property for the damage, it also encompasses the repair, such as just as much as a roof failure may encompass a roof replacement to protect the product for the damage. It also encompasses a permanent repair. But the policy language was not drafted by the insured in this case, and the case law is replete. It's incumbent upon the insurer to state clearly and unambiguously what it is that is being limited or excluded. So if they wish to limit or exclude repairs that were to protect the property from further damage and to otherwise repair the property, it should have so stated. But they can be one and the same.
So your position is that a lot of these things could be viewed as either a repair or mitigation, depending on the circumstances. Is that your position?
Correct. In other words, most of them, if not all of them, I can't state that any one of them would be solely to protect the property from further damage. There could be an instance, for example, maybe a tarp or putting a clamp on something that's temporary in nature solely to protect the property from further damage. There could be a circumstance. However, what about
the wet floors? You know, you have a flooded floor, vacuuming out the water. Why wouldn't that be a measure taken in solely in mitigation?
It would be akin to how do you perform construction? You have to assess the loss, right? Whether it's by, for example, a car accident, you'd have to assess the bent frame. In this particular case, they had to assess the moisture, and they had to implement the protocol in order to lay the predicate to start the rebuild process. You have to identify the moisture levels throughout.
to simplify what you're saying, in order to repair the floor, whoever's going to do that would necessarily have to vacuum out the water first.
But by definition, the only way that you can assess the damages and rebuild is by assessing the scope and moisture and providing a clean and safe workplace.
You can't put down new hardwood with 3 inches of water in the way, is what you're
You
saying.
definitely cannot do that. You definitely cannot live in a home or work in a home that has dangerous conditions. That's part of the rebuild process. And yes, can there be instances where it's solely protect? I think I gave the court one simple one. But in these particular circumstances, the case law is the case law. Limitations or exclusions are supposed to be strictly construed. The burden rested upon the insurer in this particular case to evidence that it was solely to protect the property from further damage, that it was not otherwise covered under coverage A, because again, the operative limitation only applies.
Also, does it matter that, does it matter what your purpose was in doing it, right? Your client's, right? So if your client had arrived to replace the floor and therefore vacuumed up the water, maybe that's different than your client just shows up only to vacuum up the water.
Well, certainly that would be a closer question of fact. It's still a question of fact. I mean, the question would be, my client.
Well, and the second option, your client is there solely in mitigation. Your client is not there to replace the floor.
My client was there to assess the conditions, assess the leak, repair the leak, remove the damaged debris, remove the contaminated debris, dispose of the contaminated debris. And what my client says doesn't define his actions. Titles are just titles. Ultimately it's an actuality, and there's no definitive term. Sorry.
Yeah, I'm trying to break it down and simplify it a little bit. So I'm talking specifically. I thought I saw in your invoice, maybe I'm misremembering it, but I thought in the invoice I saw one item for cleaning up standing water on the floor.
Yes, sir.
Okay, so sure. That's correct.
Correct.
And your client didn't repair the floor. They just removed the water from the floor, correct?
As defined as category 2 and 3 water. And that takes us back to the additional coverage for bacterial contaminants. If it's for the purpose of assessing or otherwise remediating bacterial contaminants, wet rot, bacteria, fungi, under those circumstances, there would be a $10,000 payment provision under the additional coverages, therefore, which would otherwise be excluded under coverage A. If you look on juxtaposition with the repair contract with rapid response, it doesn't encompass the same. And that fell outside the scope of the repair contract.
And that's at 82 in the record?
The
additional
coverages as referenced, yes, would fall under, starting off on 81, stemming to 82. It's paragraph 11 of section E, additional coverages. You have section A, B, C, D, and E. And as cited in the brief, Ceballos versus Systems Property Insurance Company, a 2007 Florida Supreme Court case, the Florida Supreme Court looked upon the dictionary to say, what does the word additional mean? And the word additional means just that, what we all understand to mean. It's an addition to the primary coverage under coverage A. And when you look at the endorsement, it uses capital letters vis-a-vis reasonable repairs and under what circumstances the $2,000 payment limitation applied withdrawal application. And it's not as a whole. It's, again, as defined in the endorsement, which it's per the contract with rapid response, which is solely to protect from further damage. If you draw a juxtaposition of any repair contract, I'm sure the court has had the benefit of that. What does it provide for? The removal and disposal of the damaged items. Just as much as if you were in a car wreck and you had damaged fenders and damaged windows, you have to remove and dispose of those items as part of the repair process. You have to draw the assessment of the conditions in question.
As to your second argument, what material fact were you trying to establish by seeking additional discovery?
The additional fact would be under the repair contract with rapid response, because rapid response has different repair contracts. They have one solely protected property for the damage, which, like I indicated, doesn't account for the removal and disposal of toxic materials or damaged debris. That would fall under the general rebuild contract, which would be the removal and disposal of, amongst other things, in this case, the damaged baseboards in 6 different areas of the home. So it's always been evidence that the field adjuster, in my experience, the field adjuster would go out there and, without regard for reasonable emergency measures or these type of services, would account as part of the repair process, just as much as if nobody had gone out there. Once you have elevated moisture levels affecting porous, semi-porous building materials within a home of in excess of 20% pursuant to the IICRC guidelines, it's category 2, 3 water is documented, and it has to be removed and disposed of in all affected areas. The only way that you can identify those affected areas is to hire, as in this case, or otherwise account for the cost of, someone who is trained, experienced to draw the moisture assessments and the thermal imaging, which was.
Just so you're aware, Mr. Font, you are within your rebuttal time.
Okay, well, I
You
guess
can continue if you want to reserve as much of this.
I'll draw the pause there just to save my 5 minutes. That's okay.
Thank you, sir.
Thank you.
All right, Mr. Swift.
Good morning. The case that we're talking about here is predicated on the facts as presented to the judge in the underlying case. And some of the arguments that were just made, while they appear to be lucid, were not what the judge was confronting when we had our summary judgment motion.
And there was no transcript, correct, of that hearing?
There may have been, Judge, but it wasn't part of the record.
And how does that play into our review here?
Well, I think that 2 ways. One is, of course, it's a de novo review, so you have the relevant record that relates to what the lower court would have seen. However, what it prohibits is for this court to look at any of these arguments that are being made now that weren't presented in response to the summary judgment, or really in part in the brief, if that answers your question.
Yes, thank you.
The case we have here, and there's been discussion about this invoice, and the invoice has ultimately become part of the record on appeal. The invoice that's been discussed is this multi-page document that lists several line items as to what Carabeo, what the appellant claims that they were going to do or did. But if you look at the actual presentation of the testimony at the summary judgment hearing, there was a 25-paragraph affidavit filed by Mr. Carabeo in opposition to the summary judgment motion. And attached to that is his invoice that he's actually relying on, which is a 1-line item invoice for $17,000 and change for water mitigation services. And if you look at the affidavit, there was nothing in that affidavit anywhere that suggested in any way that Carabeo had done anything other than water mitigation services, which it's undisputed are clearly and fully encompassed in the services agreement that People's Trust entered into with Rapid Response.
Why does it matter if it's covered in the services agreement, counsel? Why shouldn't we just instead look at the policy to see how to categorize that type of work?
Well, I think in part you do, but the issue is based upon the wording of the policy, which is clear and unambiguous. The policy says, if you do not notify us, and I'm paraphrasing, of course, if you do not notify us, we will pay what we would have paid Rapid Response to do the same work.
That's only if it was solely for mitigation, correct?
No, not really. Not if you read the actual language of the E023 endorsement, which talks about reasonable repairs. It talks about repairs to covered property. And so we can get into the weeds about the differences between that provision and coverage A.
Are you talking about additional coverages?
Yes, additional coverages. If you look at the
How does that not apply to repairs made solely to protect the property from further damage.
But if we're talking, I just want to make sure we're talking about the same language. The
Yeah,
language.
why don't you give me a record site so we're looking at the exact same provision?
Sure. The E023 endorsement starts on a record at page 120. And so the language, if the court has gotten there, supplants the language in the main form of the policy regarding reasonable repairs, and instead indicates, what we will do, meaning People's Trust will do in order to take care of.
I guess I don't understand, counsel. I mean, that we're looking at the same provision. It says reasonable costs made solely to protect the property from further damage. What's unclear about that?
I'm sorry, Judge, maybe I was thinking about the first portion of the actual reasonable repairs language, where it talks about making repairs. It does say that. And so I don't want to get off track on that argument. Yes.
But I mean, isn't that important though? I mean, isn't that the distinction? The policy says, look, there's coverage, and then there's primary coverage, and then under additional coverage, it says, look, if there are things you need to do solely to prevent further damage,
Correct.
Here's how you do it.
Correct. That is absolutely.
And you're saying all of this stuff was solely to prevent further damage, right?
Correct. And that's undisputed in the record. And so I apologize if I got off track on the language, but this is clearly undisputed. There is no testimony, record evidence or otherwise, that Carabao Carpet performed any repairs.
Let me ask you this.
Sure.
Assuming that they established, for instance, drying out I think they call it the wall cavity, right? You're just in between the wall where there's water. Why isn't that a repair? I mean, that's not a temporary thing done, or is it? I mean, is that a temporary thing done just solely to prevent further damage, or is that a repair to the wall?
It's not a repair.
Why not?
I'll tell you why, and I just want to make sure we're clear that that's not an issue in this case. But why it's not a repair is because they're coming in to mitigate this loss, as was actually explained during the initial argument by counsel, in order to then assess and determine what repairs need to be made. So you have to dry out the wall to prevent, as Judge Wozniak said, mold growth and additional damage. But you're not drying out the wall if you're going to then turn around and replace the wall. You're just not doing that. So
but if you're not going to replace the wall, why wouldn't drying out the wall be a repair?
Well, I don't believe it's a repair because you're not repairing anything. You're just not getting in there.
You don't think a dry wall is supposed to be dry versus wet with water in the middle of it?
Well, I don't dispute that, Judge. But what you're talking about is an issue that, depending upon the level of moisture. So if I drop
Counsel, I guess the problem is this is your language. Where do we draw the line? Your language, you drafted this, your client drafted this, says if the repair is made solely to protect the property from further damage.
Correct.
So, I mean, where do we, did this become a factual question for the jury to determine? Is drying out the wall a repair, or is it a repair made solely to prevent further damage? I mean, where do we draw that line?
Well, I think that anything could be a factual question if there are facts.
Should we reverse?
Well, no, because there are no facts in dispute in this case. If you look at how this was presented, we shifted the burden to them to prove that what they did or how they did it somehow was beyond what would have been paid to Rapid Response under the services agreement. They didn't do that.
No. You keep referencing the services agreement. Reference the provision that you're going under in the policy, the additional coverages.
Sure. So we
Because
tell
you agree, appellant didn't have your services contract, right, when they did this work. All they had was the policy.
Well, yes, if they're stepping into the shoes of the insured, they would have had the policy. That's
The
correct.
policy controls, right, not your agreement with rapid response.
The policy controls with respect to coverages afforded.
So
correct.
Answer the question based on the policy language, not on your contract with rapid response.
Sure. Based on the policy language, to the extent that work is done solely to protect the property from further damage, we will pay up to $2,000 or up to what rapid response would do, because there's other types of losses that they handle in the service agreement. So everyone talks about $2,000, but there's others for that reason. And the reason why the judge properly found.
And you established in your motion that everything that was done solely to protect from further damage. Is
Correct.
that your position?
Correct. And not only that, there's an important factor that was briefed. There was no reply brief. There was an important factor that was briefed by the appellant, which was incorrect. And that's a very important factor in this case, which is that People's Trust elected to repair this property. So whatever assignment that Carabeo had is limited because People's Trust has the absolute and sole right to elect to repair the property. They did that. And so while it may seem counterintuitive if, other repairs aren't done prior to their repairs, they're responsible to bring the house back to its pre-loss condition once they elect to repair. And they did that. And so, there was a discussion, it wasn't made during argument, but in the brief, that this AOB contract was for more than mitigation services. But if you look at the complaint specifically says in paragraph 12, they're suing for mitigation services. It doesn't say.
That's a conclusory term, counsel. Tell us what they did and why it was mitigation services under the policy.
Sure. What they did was they dried out the house. That's what they did. And they applied, I don't know that the record reflects this because their invoice, while it was in the record, was not really relied on them during the argument. The one line invoice for water mitigation services is what they really argued. But what they did here was they dried out the water that you would expect. They applied, apparently, we're not disputing they did. We don't know for sure, but we're not disputing. They applied an antimicrobial.
It seems like antimicrobial, you have a decent argument there, right? That would be to, the only purpose of that seems like it would be to prevent further damage, right?
Correct. And then in the same thing with what they claim was a minor plumbing repair, because that's done to prevent further damage. The plumbing itself is not covered because it's wear and tear. I don't think there's any dispute about that. So they do the minor plumbing repair, which is to prevent the water from spewing all over. They dry the house out. They apply the antimicrobial. That's what they did.
What is the thermal imaging for? Is that to find where the leak is or where the damage is?
I suppose that's what they're doing. There's a lot of dispute over how valuable that is, but that would be what they're doing. Again, they're trying to prevent further damage. What is here? What do we need to do? How much drying do we need to do? But again, it's our view that it's abundantly clear in this case that all the work done was solely to prevent further damage to the property.
So is it your position that as a matter of law, anytime a contractor comes in and dries out a property, that's purely and solely to prevent further damage? That's never part of the repair process?
Well, I can't say that as a matter of law because there could be some instance somewhere where, under a certain set of facts, more work is done. But I can tell you that I haven't seen it in my career where someone is drying out a property and that is somehow considered a repair. It's just not done that way because
Well, how would you repair a floor without getting rid of 3 inches of water first?
You would, but it's two different things. One is preventing further damage, getting rid of the water, and the other is repairing the floor.
No. Let's say the floor is completely damaged. It's a complete loss. Okay. So when you remove the water, you're not trying to prevent any further damage. The floor's done. All right. The floor's gone.
Right.
Needs a complete replacement. When the contractor comes in to put in the new hardwood or the new carpet or whatever it is, do they need to remove the 3 inches of water or no?
Well, it would be silly for me to say no, but I guess I would say I don't know, because it would depend upon the contractor, or it would depend upon what else is damaged. And I think that the hypothetical is somewhat incomplete, because if you have 3 inches of standing water, it's going to be wicking up into the walls. And you can't just say, we're just going to let it sit there for a month, because then the whole house will be destroyed. So that's why I draw the distinction between.
Well, in my hypothetical, the loss is complete. There's no need to prevent further damage. The damage is fully done, 100%. Now you're just coming in to rebuild, right? It seems like, at least in some circumstances, removing that 3 inches of water would be part of the repair and reconstruction process.
I don't agree with that,
Okay.
Your Honor. I believe that because your hypothetical suggests that it's a total loss, which to an insurance person means the whole house is destroyed.
No. You're fighting my hypothetical. I said the floor was a total loss, and then you said, well, but you also have drywall. Okay, so fine. So the drywall is a total loss. The point is that nobody goes in to remove the 3 inches of water because it's determined that they won't do any good. The damage is done. A few weeks later, the contractor comes in to rebuild the floor, rebuild the drywall, and at that time cleans out the water. Why is that not part of the construction process, the rebuilding?
Well, I guess it could be, but I would suggest to the court that that water would have dissipated and evaporated and been in the walls and been really gone, and all they're really doing would be then to get rid of the materials that they're replacing.
Mm-hmm.
I
Wouldn't that depend on the amount of time and the weather and things like that, whether it was evaporated? I mean, we're sort of fighting the hypothetical still, I think.
Well, I'm not really trying to fight the hypothetical, Judge. I'm trying to deal in practicalities and what actually happens, as opposed to scenarios that could possibly happen. And in this particular case, none of those things happened. We know for a fact that the only work they did was mitigation work.
I mean, is that the argument you're trying to make, that look, that hypothetical doesn't apply here simply because they were only coming in to get rid of the water. They didn't get rid of the water to then repair the house.
Correct. And again, I want to go back to this because it's important, because you have these competing interests with the insured's ability to assign their rights versus the company's ability to elect to repair. And they elected to repair this house, so there would have been no circumstances under which Carabeo would have the right to do any repairs, because my client elected to repair. And so we would be dealing with a whole different set of circumstances had they been repairing the house.
In other words, when we're looking at what was done, the purpose that it was done for, the contractor's purpose in doing it matters.
Well, I think it does. I mean, I know that the argument was no, it doesn't matter, but I think it does. I mean, I think, in some instances you can say it doesn't. Again, I think those kind of things do depend in part on what's going on in the house. But here, dealing with these set of facts, we have a situation where they did the work. People's Trust wasn't notified. Actually was a lawyer involved who reported the claim the day after Carabeo started doing their work, and People's Trust never found out about the mitigation work until 2 weeks later. And so, the issue is, what does the policy do and say in those circumstances? And I'll submit to you that it's undisputed that People's Trust complied with their obligation under the policy. I'm happy to entertain other questions. The only thing I wanted to touch on was this discovery issue. And I think it's abundantly clear from the record that after the initial discovery was completed in January of 2019, no other efforts were made to do any discovery until the end of May of 2020. The summary judgment motion had been filed in September of 2019, had been set for hearing in March and then reset for various factors for June. And during that entire time, no effort was made to do any additional discovery. So we understand appellant's position, but it has to be a good faith effort to conduct discovery, and there has to be due diligence. And I don't see where that was. So if there's no more questions, I just want to wrap up and summarize. Again, I know it's brief, but our position is that under these facts, the undisputed facts, the judge was correct in granting People's Trust summary judgment because the only work that was done was mitigation work. It's only covered in one place. That coverage is limited, and People's Trust complied, and it's undisputed that they paid for what they owed.
All right, thank you, counsel. Counsel for the appellant, you have 4.5 minutes.
Counsel,
muted.
you are muted.
Counsel for the appellee said there's no dispute that the failed and repaired plumbing system was not covered. I'm not sure where that's from because there's no basis to state that it was not a covered loss. This policy provides coverage for any direct physical loss to property, and pursuant to Florida Supreme Court case law, Fayad versus Clarendon 2005, it says any and all losses and expenses flowing, which I think the court drew the examples. If your house is flooded and you have to start the repair process, part of that repair process to remove all the damage, debris, and moisture and contaminants within the property. Here, there's 41 line items contained in an invoice. It starts off on record 182. That's part of our memorandum of law that was filed on May 26, explaining to the court that they have not met their burden. And to the extent the court's going to consider it, it would have to be considered in the form of an individualized form, because words are used in this industry, whether you call it remediation services or mitigation services. Again, it's what in fact was done, and pursuant to the endorsement provision, what would be the reasonable cost to repair under coverage A, because it was up to them to show that it was solely for the purposes of protecting property for the damage.
But I mean, look, counsel's point is, as far as your client was concerned, I mean, it seems like there's a decent argument that it was solely to protect the property. I mean, your client wasn't there to restore the property, to rebuild, right?
Well, the client was there to commence the repair process, which step one is to repair the plumbing system. I'm not sure under what theory repairing a failed plumbing system is not a covered loss under coverage A. And in fact, Ms. Peters, the corporate representative, who's a lawyer, who's testified hundreds of times, she can identify one under coverage A that would be limited or excluded under the payment provisions of coverage A. That's not solely to protect the property for the damage, nor is the disposal of contaminants. If you look at line items contained on the page 185, 132, it talks about the category 2 and the category 3 water. Can you maintain, as part of the repair process, contaminated water that creates a toxic condition for the workers and the homeowner? Is that solely to protect the product for the damage? No, that's part of the repair process. Part of the repair is to remove the contaminants from the home, and it's set forth in the affidavit.
But you weren't. Your client wasn't there to repair, really, right? I mean,
well, if repair is defined as part of the repair process, whether it's step one of assessing where is the loss, where is the water coming from,
so like a piecemeal repair, like you guys start the repairs and then the insurance company comes in and finishes them.
yes, it's absolutely testimony that you would derive from any person in this profession that a general contractor is not a jack of all trades. They're going to rely upon folks like these individuals that are IICRC certified, that use thermal imaging, moisture assessments, and otherwise are trained to remediate contaminated materials from property. It would be no different than a toxic spill. Water is exceptionally hazardous. It's one of the most significant considerations that ensue from a covered loss. Because what is the efficient proximate causal loss? It's a failed plumbing system. The ensuing conditions required, amongst other things, the detection and repair of that failed plumbing system. So by Ms. Peters signing an affidavit or interrogatories that are all objected to, no reference is made to a limitation or exclusion of coverage A or what they otherwise would have paid for the repair of the plumbing system or the removal of the contaminants, or why it's not covered under the additional coverages for debris removal or additional coverages for contaminants for bacteria, wet rot, dry rot, fungi. Those are all separate and distinct coverage provisions for which the insurer is entitled to have an insurance company go section and coverage provision by coverage provision. And again, contaminants are excluded under coverage A. Fungi, wet rot, dry rot, bacteria are expressly excluded under coverage A. And as exemplified by Ceballos versus Citizens, the court said in that case, law and ordinance was excluded under coverage A. And the only time you get to it is when you exhaust coverage A and then you go to the additional coverages. And law and ordinance in that particular case was 25%. Here, mold was excluded. However, up to $10,000.
I thank you, counsel. That is your time. I want to thank you both for this very well briefed and well argued appeal. The court's going to stand in recess at this time. Have a good day.
Very
Thank
good.
you.
Thank you.